Welcome back to FDVN channel, where we share current legal issues, dissemination, free legal advice, tell stories about the legal profession, provide legal knowledge. The channel also discusses professional issues, practice stories of the legal profession in Vietnam nowadays. Labor is the most important human activity in terms of producing material wealth and spiritual values for society. Employers frequently believe that they have the right to unilaterally terminate labor contracts with a definite term of 30 working days, labor contracts with no time limit of 45 working days. This is also one of the causes of labor disputes, which have an impact on production, business, and enterprise reputation. However, under current law, the employer is only allowed to unilaterally terminate the employee's labor contract if it falls into one of the cases prescribed by law and ensures that it has notified the employee before a certain time, unless the law allows the employer to do so without prior notice. Today, we'll discuss the legal provisions related to the above issue. First, the right of an employer to unilaterally terminate the employment contract. According to Article 20 of the Labor Code 2019, an employment contract shall be concluded in one of the following types: 1. An indefinite term employment contract. 2. A fixed term employment contract is a contract in which the two parties fix the term of the contract for a duration of up to 36 months from the date of its conclusion. According to Article 36 of the Labor Code 2019, an employer has the right to unilaterally terminate the employment contract in the following cases. First, the employee repeatedly fails to perform his/her work according to the criteria for assessment of employees' fulfillment of duties established by the employer. The criteria for assessment of employees' fulfillment of duties shall be established by the employer with consideration taken of opinions offered by the representative organization of employees, if any. The second, the employee is sick or has an accident and remains unable to work after having received treatment for a period of 12 consecutive months in the case of an indefinite term employment contract, 406 consecutive months in the case of an employment contract with a fixed term of 12 to 36 months, or more than half the duration of the contract in case of an employment contract with a fixed term of less than 12 months. Third, in the event of a natural disaster, fire, major epidemic, hostility, relocation, or downsizing requested by a competent authority, the employer has to lay off employees after all possibilities have been exhausted. Fourth, the employee is not present at the workplace after the time limit specified in Article 31 of the Labor Code. Fifth, the employee reaches the retirement age specified in Article 169 of this Labor Code, unless otherwise agreed by the parties. Sixth, the employee is not present at work without acceptable excuses for at least 05 consecutive working days. Seventh, the employee fails to provide truthful information during the conclusion of the employment contract in accordance with Clause 2 Article 16 of this Labor Code in a manner that affects the recruitment. Thus, the employer is only allowed to terminate the labor contract with the employee when falling into one of the above cases. Besides, the employer must give prior notice to the employees as prescribed in Clause 2 Article 36 of the Labor Code 2019 as follows. At least 45 days in case of an indefinite term employment contract, at least 30 days in case of an employment contract with a fixed term of 12 to 36 months. At least 03 working days in the case of an employment contract with a fixed term of less than 12 months and in the cases the employee is sick or has an accident and remains unable to work after having received treatment for a period of 12 consecutive months in the case of an indefinite term employment contract, 406 consecutive months in the case of an employment contract with a fixed term of 12 to 36 months, or more than half the duration of the contract in case of an employment contract with a fixed term of less than 12 months. For industries, occupations, and specific jobs such as aircrew members, aircraft maintenance technicians, aviation repairmen, flight coordinators, enterprise managers, and more, the notice period shall comply with specified in Article 7 of Decree 145/2020/NDCP. However, an employer shall have the right to unilaterally terminate an employment contract in one of the following circumstances. The employee is not present at the workplace after the time limit specified in Article 31 of this Labor Code. The employee is not present at work without acceptable excuses for at least 5 consecutive working days. According to Article 39 of the Labor Code 2019 and the above provisions, the employer's unilateral termination of the labor contract without falling into one of the cases permitted by law or not giving notice to the employee on time, except for cases where notices are not required, the act of the employer is considered an illegal unilateral termination of the labor contract. Accordingly, the employer will have to bear legal consequences under the law. Second, the legal provisions for handling cases of employers illegally unilaterally terminate the employment contract. Article 41 of the Labor Code 2019 stipulates the obligations of the employer upon illegal unilateral termination of the employment contract. Depending on the case, the handling shall be as follows. The employer shall reinstate the employee in accordance with the original employment contract. At the same time, must to pay the following amounts: the salary for the period during which the employee was not allowed to work, social insurance, health insurance, and unemployment insurance premiums for the period during which the employee was not allowed to work, 2 months' salary specified in the employment contract. After the reinstatement, the employee must return the severance allowance or redundancy allowance, if any, to the employer. Where there is no longer a vacancy for the position or work as agreed in the employment contract and the employee still wishes to work, the employer shall negotiate revisions to the employment contract. Where the employer fails to comply with the provisions on notice period in Clause 2 Article 36 of this Labor Code, the employer shall pay a compensation that is worth the employee's salary for the remaining notice period from the termination date. In case the employee does not wish to return to work, in addition to the compensation prescribed in Clause 1 Article 41 of this Code, the employer shall pay a severance allowance in accordance with Article 46 of this Code to terminate the employment contract. Where the employer does not wish to reinstate the employee and the employee agrees, in addition to the compensation mentioned in Clause 1 of this article and the severance allowance mentioned in Article 46 of this Labor Code, both parties shall negotiate an additional compensation which shall be at least 2 months' salary under the employment contract in order to terminate the employment contract. The third, protect the rights of the employer. Legal options to protect the rights of employees are as follows: to negotiate with the employer, approving the labor mediator as prescribed in Articles 187 and 188 of the Labor Code 2019. Initiate a lawsuit at a competent people's court for settlement. Under the provisions at Point A, Clause 1, Article 32, Point C, Clause 1, Article 35, Point A, Point B, Clause 1, Article 39, Point D, Clause 1, Article 40 of the 2015 Civil Procedure Code stipulates that the employee has the right to choose the district-level people's court where the employer is headquartered or where the employee resides to settle this dispute. The unilateral termination of the labor contract can be in writing or verbally, any form, through specific acts such as not arranging work, do not allow the use of working means to seal the working room, do not pay wages to employees, so this dispute is determined as a dispute about unilateral termination of the labor contract, not about the request to continue performing the labor contract. In addition, when signing labor contracts with employees, the employer often makes provisions such as restricting early marriage, not having children early, etc. Employees wishing to have a job or do not understand the law would accept to sign the labor contract. The employers would terminate employment's contract with employees who fail to comply with the provisions above. In summary, the Labor Code of 2019 has many amendments and supplements compared to the 2012 Labor Code on provisions related to the right to unilaterally terminate the labor contract of the employer, the subject who holds the management power in the labor relationship. Accordingly, the right of the employer to unilaterally terminate the labor contract is expanded and regulated in a more favorable direction. The Labor Code 2019 also adds a case where an employer is entitled to unilaterally terminate a labor contract with an employee without prior notice. With these changes to the Labor Code in 2019, it will be easier for employers to exercise their right to unilaterally terminate their labor contracts, be proactive in the process of labor management, and ensure the maintenance of production and business activities. However, that unilateral right must not be exercised arbitrarily but must be for good reasons specified in the Labor Code. We hope that the information in today's video is useful to you and your friends. Please like, share, subscribe, and support the FDVN channel on YouTube for more interesting legal information. Goodbye and see you again.